Hello, I'm going to do a quick read through, maybe not that quick, probably 15 minutes, if you can bear sitting through 15 minutes of my banal dribbling voice. I'm sure it's very relevant and hopefully you'll find quite informative and interesting. This video is made for educational purposes only, and I've discussed this entire document with the ward manager of Hayward Ward, where I'm currently situated in room 15. She said that it was fine for me to share this document and for to read it online, provided that I don't share any staff's details or breach confidentiality, or there's no other audible parties involved. I've had to do 3 takes of this video because the first time I was kind of halfway through and then a staff member came and knocked on my door and started very loudly introducing themselves with a paper copy of this document as a PDF, which I just tried to email twice and they said the email hadn't gone through, and then as soon as I started making the video on my phone, the email of course then arrived and she came and knocked on the door, so I had to do another take, and then I've had to do a second take because one of the other service users started texting me and WhatsApping me halfway through, and I can't detail their names on the video either. But those things are just coincidence, and hopefully I'll be able to do this take in a single take without having to go back over and start reading this long document from the top. But anyway, here's that long document from the top. Without further ado, the following information is shared for educational and discussion purposes only. It presents as a hypothetical scenario exploring potential legal and insurance implications related to mental health detention. The questions asked to Gemini and the responses provided are based on theory and deduction and are not intended to represent factual allegations against Signet Q-Stoke or any other individual or entity. Its content should not be interpreted as an accusation of wrongdoing, nor does it constitute legal advice. I do not have evidence to support any accusation of Signet Q-Stoke perverting the course of justice. I acknowledge that any detention I am subject to is lawfully performed. I expressly disclaim any liability for any reliance on this information. Readers are advised to seek professional legal counsel for advice specific to their circumstances. This information is not intended to be defamatory, slanderous, or libelous. And there's my signature and the date. Here's a transcript of a conversation I had with Gemini AI, during which I gained valuable information about the ramifications of various scenarios. They are unedited, and although not intended to defame or accuse Signet Q-Stoke of crime, I'd like to provide several facts which, although do not constitute evidence of crime, have significantly initiated my research on the topics shared below. As I've been offered the right to view my medical legal scrutiny checklist only on a computer, I have no legitimate proof or substantiating evidence to suggest or imply that I am presently subject to an unlawful deprivation of liberty. However, on the Information Commissioner's Office webpage entitled Right to Data Portability, it says that the right to data portability entitles an individual to receive a copy of their personal data and or to have their personal data transmitted from one controller to another controller. So it should be okay to have a printed copy of a medical legal scrutiny checklist. I've been sectioned before in 2019 without medical legal scrutiny being completed. Detention and assessment by approved mental health professionals was orchestrated by Signet Healthcare. Here's a link to a letter from NHS Devon Partnership Trust Mental Health Act Administrator confirming this, dated the 4th of September 2019. That letter from Kitty Granger reads, I can confirm you're in receipt of the Section 2 and Section 3 papers for your admission to hospital. However, on both section papers there is no medical/legal scrutiny checklist. I've got a copy of that in my folder in my security lockup, or I should have the original copy with all my mental health documents that I've got from my place of residence. There's a link to that on Google Drive. For anybody that wants to look at the PDF, you can download a copy of that letter and check it with the Haytor Ward, Torbay Hospital Mental Health Act Administrator for validity if you so wish. Here's a short accompanying video I made on that specific detention during 2019. I'm going to just turn off airplane mode briefly. Hopefully I won't get any more bullshit notifications to invalidate my video or breach its privacy. So here is that video.
Okay, so what is unlawful detention? I'm going to explain really quickly. So this is NHS policy document N14. It says that you need something called medical legal scrutiny if you want to be detained lawfully under section. Medical legal scrutiny is a really important checklist completed by the mental health act administrator that makes sure that all your details are correct. Being detained under section is a little bit like going to prison. If you don't have it, then your section's unlawful. It's listed as a crime on the Crown Prosecution website and comes under the heading of false imprisonment. In May 2019, I was detained under the Mental Health Act outside Asda in Newton Abbot. I spent 3 months in hospital, but when I got to Torbay at the end of the detention, the Mental Health Act administrator investigated my detention and found out that it had been unlawful. The MHA in Torbay printed out my Section 2 paperwork from the 16th of May and my Section 3 paperwork from Darlington from the 7th of June and wrote me a letter to say that there was no medical legal scrutiny on either. I tried to phone the police to report this, but they confiscated my phones and didn't give me a receipt a week later. Then I found out that my consultant wasn't qualified either. I tried to ask for a replacement consultant and eventually they kicked me out of the ward with nowhere to go after that. It's the 4th of November 2020, not at Signet Taunton. Check out the link in the description.
So just to be expressly clear, I say in that video that it de facto means it's unlawful, which isn't actually, based on what it says in this video and what I've come to understand, necessarily the way it is. Let's get back into it and you'll see what I mean. But there's that video. You can see there's links, I believe, in that video's description to the various documents that are displayed there. There's a copy of a proper medical legal scrutiny checklist and details of my consultant psychiatrist in 2019 who was not on the specialist register, which meant that with GMC she wasn't qualified to consult. I understood, I believed, or I thought at the time. So it goes on after that video. Any references to perverting the course of justice or research I've conducted regarding what might happen, let's just go back into airplane mode so we don't get any notifications. What might happen if a hospital denied a patient was being treated to the police are purely speculative. I have had information misrepresented in multiple parts of my Section 132 rights form. This includes errors with first and second name, using the hospital telephone number instead of hospital number, getting the section details wrong, putting down 2 instead of 3, and omitting at the point I was requested my signature to endorse the document. That sentence was supposed to say something else, but I haven't fully ironed this out. I'm just getting it online because I think it's the right thing to do. Although I requested my hospital number be input on more than one occasion, this has not been duly and properly completed. The only evidence I have to demonstrate these administrative errors is the below document where my name appears to be Macleod instead of Macleod, and the hospital phone number is listed where the hospital number is supposed to be. These correspond to medical documents and should be well understood by any RMN who completes identical 132 rights forms every 14 days for every patient throughout their career working in a clinical setting. I cannot name the RMN due to confidentiality policies, but I can show you that somebody put in a phone number where it says hospital number, and this was the second attempt after my name was spelt Brodie Macleod, Bodie Maclead. She came back and it said Brodie, Brodie, or if you look really closely, it sort of looks like a C and an L, maybe it could be broccoli. And I would say that the A there looks quite similar to the other A there, so it does sort of still say Brodie Macleod. I've got a separate presentation of just how many times this name has been spelt wrong on loads of different documents every single day, and how staff don't print their names. They've got very unusual Nigerian names and names from various places in Africa that I've never heard of. And when you see it and joined up writing on a document, it's just illegible. There's no way to actually, for me to identify whose name I'm reading, but I'll do some other work on that separately. So, below is a transcript of the research I conducted using Gemini AI. Again, this does not constitute legal advice and is purely hypothetical. with the facts above being taken into consideration. So I asked Gemini AI, again without a question mark, this is just from voice search, is it a crime to detain a British citizen under a section of the Mental Health Act without a medical legal scrutiny checklist being completed? The definition of this circumstance constituting unlawful detention, which was my opinion when I was asking, implicitly denotes that this is a breach of the law and so therefore a crime. Which law exactly does it break, and how can it be duly reported to the police in the instance that necessary documentation to evidence the unlawful deprivation of liberty hasn't been provided, and the company detaining the citizen has repeatedly lied to the police, claiming the citizen is not detained at the premises in order to prevent themselves from going to prison? Understanding the complexities of detaining a British citizen under the Mental Health Act requires careful consideration of legal procedures. Here's a breakdown of the key points. Mental Health Act and lawful detention. Mental Health Act 1983, amended 2007. This act governs the assessment, treatment and detention of individuals with mental health disorders in England and Wales. It sets out strict criteria and procedures must be followed for a detention to be lawful. Lawful detention requirements. Detentions under the Mental Health Act must be justified by specific criteria, including the presence of a mental disorder and the need for detention in the interests of the person's health or safety or the protection of others. Proper documentation, including medical recommendations and application forms, is essential. Scrutiny of these documents is vital to ensure compliance with the Act. Unlawful detention. Failure to adhere to the required procedures, such as missing or incomplete documentation, can render a detention unlawful. Unlawful detention is a serious matter that can infringe on an individual's human rights. Potential legal breaches, deprivation of liberty. Unlawful detention can constitute a deprivation of liberty, which is a violation of Article 5 of the European Convention of Human Rights, incorporated into UK law by the Human Rights Act 1998. This means that any detention must be in accordance with the law. Potential for false imprisonment. If a person is held against their will without proper legal authority, then a legal action for a civil action for false imprisonment could be taken. Breaches of the Mental Health Act 1983. Failure to follow the correct procedures within the Act is a breach of that Act itself. Reporting to the police. Reporting unlawful detention. If you believe someone is being unlawfully detained, you can report it to the police. Provide as much information as possible, including the person's name and location, the circumstances of the detention, any evidence of procedural irregularities, any evidence of false information being given to the police. Evidence and documentation. Gathering evidence can be challenging, especially if access is denied. However, any available documentation, witness statements or records of communications can be valuable. If a company is giving false information to the police, that is a crime in itself of perverting the course of justice. Now, just to be clear, before I go on, the police have attended the ward numerous times since I've been here. Nobody's come to ask me if they've conducted a welfare check on me or had anything to do with me, but they have been many times to the building, and I've no reason to believe that any false information has been given to the police, unless somebody has kind of said, have you got a Brodie Macleod there? And they've said, no, we've got a Brodie Macleod here. And they've said, oh, different person. That's the, unless they've misspelt my name and that's led to a potential perversion of the course of justice unintentionally, that wouldn't be a crime anyway, because it's just a simple administrative error. Seeking legal advice. It's strongly recommended to seek legal advice from a solicitor specialising in mental health law. They can provide guidance on your rights and options. Important considerations. Mental health law is complex and each case is unique. The police and other authorities have a duty to investigate allegations of unlawful detention. It's very important to document all interactions with all parties involved. I hope this information is helpful. I then went on to ask what crimes specifically should be reported to the police in the instance that a proper medical legal scrutiny checklist has not been completed. AI said back to me, when considering reporting a situation where a proper medical legal scrutiny checklist has not been completed during a Mental Health Act detention, it's important to focus on the potential legal breaches that result from this procedural failure. Here's a breakdown of the relevant areas. Key legal concerns. Unlawful detention, false imprisonment. The core issue is that the absence of proper legal scrutiny can render the detention unlawful. This directly relates to the crime of false imprisonment, which is the unlawful restriction of a person's freedom of movement. This is a significant violation of personal liberty. Breaches of the Mental Health Act 1983. So a failure to adhere to the statutory requirements of the Mental Health Act 1983 itself constitutes a breach of that legislation. Specifically, the Act lays down very specific rules that must be followed in order for a detention to be legal. By not completing the proper checklist, those rules are being broken, AI says. Deprivation of liberty. Human Rights Act 1998. Unlawful detention can also be a violation of Article 5 of the European Convention on Human Rights, which protects the right to liberty and security. This is brought into UK law by the Human Rights Act 1998. What to report to the police? When reporting to the police, emphasise the following. The potential for unlawful detention. Clearly state that you believe the individual is being held unlawfully due to the lack of proper medical legal scrutiny. Concerns regarding false imprisonment. Use the term false imprisonment, as this is a legal term the police will understand. Breaches of the Mental Health Act 1983. If you have specific information about which procedures were not followed, provide those details. Any evidence of false information. If the detaining party has provided false information to the police or others, make sure to report this as well, as this could be perverting the course of justice. Again, I have no knowledge that that has taken place. This is just speculatively what would be the ramifications if it had. Request a welfare check. Ask the police to conduct a welfare check on the individual to ensure their safety and well-being. Important notes. It's crucial to document all interactions and gather any available evidence. Seeking legal advice from a solicitor specialising in mental health law is highly recommended. It's important to remember that the police have a duty to investigate credible claims of unlawful detention. By focusing on these specific legal concerns, you can effectively communicate the seriousness of the situation to the police. I then asked which specific articles of the Mental Health Act are being breached in the instance of the absence of a medical legal scrutiny checklist being completed for a detention under section. AI said back to me, it's important to understand that a medical legal scrutiny checklist isn't a single codified document within the Mental Health Act 1983 itself. Rather, it's a practical tool used by healthcare professionals and administrators to ensure compliance with the Act's requirements. Therefore, the absence of a completed checklist indicates potential breaches of various procedural requirements within the Act. Here's how that translates to potential breaches of the Mental Health Act 1983. Key areas of potential breach. Requirements for medical recommendations. The Mental Health Act sets out strict requirements for the medical recommendations that support a detention. These include the qualifications of the doctors providing the recommendations, the timing of the examinations and recommendations, the content of the recommendations, which must address the criteria for detention. Failure to properly scrutinise these recommendations can lead to breaches of the relevant sections of the Act that define these requirements. Requirements for applications. Similarly, the Act specifies the requirements for the application for detention, including who can make an application and the information that must be included. Scrutiny of the application is essential to ensure compliance. Procedural safeguards. The Mental Health Act includes numerous procedural safeguards to protect the rights of individuals being detained. These safeguards include the right to information about their rights, the right to appeal their detention, the role of the nearest relative, that a lack of proper scrutiny can result in failures to uphold these safeguards. So in essence, the absence of a completed scrutiny checklist indicates that the process is designed to ensure that the requirements of the Mental Health Act have been followed, have not been correctly adhered to. It is not one single article that is broken, but the collection of articles that provide the framework for legal detention. Therefore, when reporting to the police, it's crucial to emphasise the potential for breaches of the procedural requirements of the Mental Health Act 1983, which could lead to unlawful detention. I then asked, regarding the mention of the provision of information regarding legal rights, the bi-monthly issuing of Section 132 rights has been repeatedly purposefully malfeased, that's in my opinion, with incorrect legal titles, inaccurate section details, it should say, and omission of the date of detention and hospital number. This is a clerical administrative code used by the hospital to identify patients' health records and treatment. Does this breach any specific article of the Mental Health Act? And if defined as fraud, what type of fraud would this constitute within the context of any potential police report? The situation you describe involving the malfeasance of Section 132 rights information raises serious concerns about the compliance with the Mental Health Act 1983. Here's a breakdown of the relevant legal considerations. Section 132 of the Mental Health Act 1983. This section places a duty on hospital managers to ensure that detained patients understand under which provisions of the Act they are being detained, the effect of those provisions, their rights to apply to a tribunal. This information must be provided as soon as practicable after the commencement of detention. The information must be given in a way that the patient can understand. Breaches and potential offences. Failure to provide accurate information. Providing incorrect legal titles, inaccurate section details, or omitting essential information like the date of detention and hospital number directly undermines the purpose of Section 132. This could be considered a failure to fulfil the duty imposed by the Act. Deliberate malfeasance. If the errors are deliberate and repeated, it suggests an intent to mislead or deprive the patient of their rights. This raises more serious concerns. Such actions could potentially be viewed as a form of administrative abuse. Potential fraud. While it may not neatly fit into a classic definition of financial fraud, the deliberate falsification of official records related to a person's legal rights could potentially be considered a form of fraud. Specifically, this could be construed as fraud by false representation, if the incorrect information is intended to deceive the patient about their legal status. Perverting the course of justice, if the intent of the incorrect information is to obstruct correct application of the law. Record keeping. The omission of the hospital number, which is a key record keeping detail, is also a serious issue. You've seen the document where it's got a phone number instead of a hospital number. I didn't make that document, that was given to me. Proper record keeping within hospitals is essential for patient safety and legal compliance. Reporting to the police. When reporting this to the police, emphasise the following. Breaches of Section 132 clearly state that the hospital is failing to comply with its duties under Section 132 of the Mental Health Act 1983. Deliberate falsification. If possible, provide evidence of the repeated nature of the errors and the intent to mislead. Potential fraud. Express your concerns that the falsification of these records could constitute fraud, specifically fraud by false representation and/or perverting the course of justice. Record keeping issues. Highlight the fact that hospital records are being incorrectly filled out and that this could lead to further complications. Request an investigation. Ask the police to investigate the hospital's practices and determine whether any criminal offences have been committed. Important considerations. Gather and preserve any evidence of the incorrect information, such as copies of the Section 132 forms, I've already shown you that, and seek legal advice from a solicitor specialising in mental health law. I have emailed and phoned very many, and I'm currently in progress of that action. By providing detailed information and emphasising the potential legal breaches, you can help ensure that the police take your concerns seriously. I then asked a bit of a kind of divisive question. If a vehicle was subject to a potentially questionable or invalid insurance policy, this would be a crime. Is this different from an unlawful detention where insurance is potentially questionable or invalid? AI's got back to me and said, you've raised a very interesting point about the distinction between potentially invalid insurance in a vehicle context and in a detention context. While both involve questions of legality and potential invalidity, there are key differences. Vehicle insurance, contractual and regulatory. Vehicle insurance is primarily a contractual matter derived from regulated by specific laws. Driving without valid insurance is a direct violation of those laws, leading to criminal penalties. The crime is the act of operating a vehicle without the legally required insurance. Clear legal framework. As a relatively clear legal framework defining what constitutes valid vehicle insurance. Invalidity often stems from breaches of contract, e.g. providing false information or failure to comply with regulations. Unlawful detention, fundamental rights. Unlawful detention is a violation of the fundamental human rights, specifically the right to liberty. It involves the misuse of legal powers and procedures. Complex legalities. Determining unlawfulness can be very complex, involving interpretations of mental health laws, procedural requirements, and individual rights. The crime here is the unlawful deprivation of liberty, which can lead to civil and potentially criminal liabilities for those responsible. Insurance ramifications. The insurance issues that arise from unlawful detention are very different from vehicle insurance. It is not the act of having invalid insurance that's the crime, it's the act of the unlawful detention. The insurance issues arise from the results of the unlawful act. The question of insurance coverage in unlawful detention cases is more about whether an insurer will cover costs arising from a potentially illegal act, and less about the act of holding an invalid insurance policy. So the key differences are the nature of the crime. One, vehicle insurance, obviously, is a direct violation of regulatory law, vehicle insurance. The other is a violation of fundamental rights, unlawful detention. The complexity of legal determination. Vehicle insurance validity is generally clearer, while unlawful detention involves complex legal interpretations. The insurance implications. With vehicle insurance, the act of having invalid insurance is the problem. With unlawful detention, the result of the unlawful act is the problem. In essence, while both scenarios involve questions of legal validity, they operate within distinct legal frameworks and have different consequences. I'm intending to share our recent conversations online, specifically the hypothetical scenario of Signet having lied outright to Avon and Somerset Police to the detention I'm subject to not taking place and claiming that I'm not on the premises. This is just an assumption which I don't know for certain to be factually correct. Can you advise me on how to share the responses Gemini provided, making it clear that although I asked the question, I'm not accusing Signet Q-Stoke of perverting the course of justice without evidence, and compose me a basic but sufficient legal disclaimer to make it clear my questions were hypothetical and based on theory and deduction, and not to be interpreted as allegory of fact or in any way an otherwise defamatory, slanderous or libelous. It's important to be cautious when sharing information online, especially when it involves potentially sensitive or defamatory material. Here's a breakdown of how to approach this, along with a simple disclaimer. So I've followed this to the letter. Context is key. When sharing the conversations, make it absolutely clear you're presenting a hypothetical scenario. I am making it absolutely clear that I'm presenting a hypothetical scenario. State explicitly that you're exploring potential legal and insurance implications based on theoretical situations. Emphasise that you are not making factual accusations against Signet Q-Stoke or any other party. Transparency. If you're including the text of our previous conversations, present them verbatim, which I've done. Do not alter or edit the content in a way that could change its meaning. Clearly state the questions asked to Gemini were hypothetical. They were all hypothetical questions. Avoid accusations. Refrain from using language that directly accuses Q-Stoke of wrongdoing. Focus on the hypothetical nature of the scenario and the legal principles involved. Do not publish any personal information about any person. I haven't done that. Legal disclaimer. Include a clear and prominent legal disclaimer that clarifies the hypothetical nature of your online sharing. Sample legal disclaimer you've already seen. Important considerations. Defamation. Even with a disclaimer, you could still face legal issues if your online sharing is deemed defamatory. Defamation laws vary, but generally they protect individuals and entities from false statements that harm their reputation. Evidence. Avoid making statements that suggest you have evidence of wrongdoing unless you're prepared to substantiate those claims in a court of law. The only evidence that I've got is the documents that you've seen and my section papers, which I may or may not choose to add as a PDF to Google Drive, which have not been, as far as I've seen, scrutinised. They have offered to let me see the medical legal scrutiny on a computer screen, but that's not been facilitated. I've declined that offer because I think it's farcical, absurd, ridiculous, and what I want is a copy on paper, as the ICO provides for in its regulatory legislation. To go on, legal advice. If you have serious concerns about the legality of your detention, consult with a legal professional, qualified one. Do not rely solely on online information or AI-generated responses for legal advice. Context of sharing. The platform you share the information on can change the context. Sharing on a personal blog is different than sharing on a social media platform that's known for spreading misinformation. By following these guidelines and using a strong disclaimer, you can help mitigate the risks associated with sharing sensitive information online. So, That's the end of that presentation. Taken 29 minutes and 40 seconds so far. If you've got any questions you'd like to ask me, you can email me at brodiemacleodtemp@gmail.com, all lowercase. You can get me at Brodie Likes You, all lowercase, all one word, on Twitter. You can get me on Instagram at Macleod Brodie, as it's spelt, all lowercase, Macleod Brodie, at Macleod Brodie. Or you can phone the hospital on the number that they put on that document, or you can visit me at the hospital if you'd like to, by prior arrangement, or you can phone me up on my telephone number, which is 07576 713 026. I hope you've enjoyed the last half an hour of me reading from that document, and as I said, I've read this document to the ward manager. She's told me expressly that she has my full consent she has given her full consent for me to share this document, and that it doesn't pose any risks or breaches of any of the contracts that I've signed. But if you know more than me about the way it's used as a tool, the medical legal scrutiny checklist, or whether spelling somebody's name could confuse an inquiry as to whether they're at the premises, potentially, hypothetically, in a completely theoretical context, please do get in touch. And thank you very much for everybody's ongoing support. And it's a shame that I've had to take 3 takes at this video because I've had interruptions at the door and interruptions via WhatsApp and via text message. But thank you everybody for your support, and thank you for the ongoing treatment that I'm receiving at this fine establishment.